Hey, everybody. Welcome back to the Populist Block. If you've been here before, we appreciate you coming back. And if you're new to us, it's not really a surprise. We're pretty new. We've just started this channel just a few weeks ago. But what you're going to find is we really like to have conversations each week about topics that Animal, my co-hosts, and I are interested in. And they range from all sorts of things. It can be stem cells, healthcare, AI, crypto, pharmaceuticals, some politics, some economics, really whatever's interesting to us that week. And we always want to try to find somebody who knows a little more than we do about it. So a few weeks ago, Jack Dorsey, the creator of Twitter, put a post on X and said, abolish IP law. And he means intellectual property, IP, meaning copyrights, patents, trademarks. So get rid of all those laws. And that struck me as a really unusual thing to say, but something I've heard in libertarian circles before. And so, of course, in the comments, there were a lot of people supporting him, and there are a lot of people, disagreeing with him. And I have my opinion, but I really wanted to understand what's going on here. Why would there be the two sides? Because it seems kind of logical to me that if I create something, I get a protection for it. So we were able to reach out to Brian L. Frye, not to be confused with Philip J. Frye, from the University of Kentucky. He is a professor of law specializing in IP law. So it was really a great conversation. We went back into kind of the history of how some of these things were created, why these laws persist, and maybe most importantly, how are they going to apply in the realm of AI, in the realm of NFTs and crypto? How do you have possession of something that you can't physically hold or defend? Kind of interesting. So I hope you enjoy it. Sit back, welcome to the block, and enjoy the show.
Of meeting needs will be the day we enter correct Christianity. All this Christianity of gimme is actually paganism, modern day paganism. If all your Christianity is about God, give me car, give me wife, give me children, give me this, give me that, kill my enemy, kill my enemy, kill my enemy, give me, kill my enemy, give me. Anyone that doesn't want me to succeed, die by fire, die by fire, die by fire, die by fire, die by fire. Give me this, give me that. Kill my enemy. Give me this. Give me die by fire, die by fire, die by fire, die by fire. If that is all your Christianity, you are a pagan rebranded as a Christian. You and the children of Baal are in the same WhatsApp group. I can give you a scripture. I don't talk carelessly, right? Give me.
Whether you're new to crypto or you're a grizzled old veteran, Cake Wallet should be your go-to mobile wallet. Its simple user interface makes it easy to buy, sell, and swap all major cryptocurrencies right in the wallet. And put your crypto to good use. You can buy gift cards right inside the app at thousands of retailers around the country and use your money with a tap. So get started with Cake Wallet. Simple, secure, and built for everyone. Hey, if you're looking for some ways to save money every month, make sure you check out Stack Mobile. They offer competitive data plans on the nation's largest 5G network, and they'll pay you up to 15% cash back in crypto as long as you have their service. Now imagine how that can add up for a family or a company plan. There's no long-term contracts. You keep your device, you keep your phone number, and right now if you go sign up and use the promo code BLOCK, all caps, you get a $50 upfront payment just for being a fan. It pays to stack with Stack Mobile.
Should we start with Brian?
Yeah, let's bring in Brian. Let me set up the thing here. We're going to get rid of... hang on. I get rid of this. Bring in Brian. Brian L. Frye. You include the L. That must be important for some reason. You can choose to explain that if you want. But you are... Now, your Twitter bio says you're the Dogecoin professor of law and grifting, which if you're in the crypto world and you're expert in grifting, you're in the right place.
This is the guy you want to talk to.
Right? Yeah. Well, I'm visioning, right? You got to give yourself the title you wish for.
Oh, true. Yeah, maybe you'll get picked up by the Doge Council. Yeah, we could use some. That's a whole topic in crypto. So you're UK. You're down in UK College of Law, Kentucky.
Yeah. So I'm on the faculty at the University of Kentucky College of Law, where I've taught for a little over a dozen years now. But I live with my wife in New Orleans. She's on the faculty at the Tulane University College of Law. So we live down here, and I commute up to Kentucky to teach.
Oh yeah, I have another friend that, yeah, his wife got a job in Illinois, and he was out here, and he was always here half the time. I'm like, where do you live? I don't understand. And I guess it must be a common thing because you get moved around a lot, right?
Yeah, I mean, the thing about academic jobs is they're incredibly flexible about everything that you do except for where you live. So, if you want to have an academic job, you kind of have to accept that it may come with some geographical inconvenience. So
are you just like an outlier because the crypto to me is probably making an assumption that like college professors would be kind of not into crypto, like they would look at it as,
I mean, I would say that there's a fair number of law professors who are interested in the crypto space for a number of different reasons. Some are kind of pro crypto, some are very anti crypto, but it's a lot of money involved. It's a big industry. Law professors are interested in anything that's a big industry because it
has a lot of money.
Well, it's a lot of money. It's socially significant. So there's a lot of people who spend time thinking about it. I come mostly from a kind of intellectual property space, and so there's a lot of people in the IP world who are interested in crypto. I mean, I think that especially happened after the kind of NFTs started taking off,
right?
And then the bubble sort of burst. But I think NFTs caused a lot of IP professors to start thinking more about how people are transacting in different kinds of knowledge goods in the kind of blockchain space. There's also a lot of law professors coming from the sort of banking regulation, financial transactions regulation space who are really interested in crypto, both as a sort of separate kind of market for financial transactions. And I think also as kind of a window or a kind of a new lens for thinking about financial transactions, thinking about money, right? So I'm thinking people like Carla Reyes or Rowan Gray or Willamette, right, are doing a ton of work in the crypto regulation space and thinking about the relationship between crypto markets and the kind of conventional financial markets, as it were. I mean, it's a niche interest for sure, but there's definitely a lot of people out there in the kind of legal scholarship space who've been.
Yeah, and we've done, like I said, we used to do space. This channel was Litecoin Underground. I was a crypto specific thing for about 3.5 years. In our spaces, I would say we were amateur lawyers in a lot of debates talking about specifically the thing that I find most interesting is the idea of real world asset tokenization. And what I think crypto does is it's a new, like you said, a new lens where there's this thing all of a sudden that like, wait, this is an ungovernable space. Like, how do I govern the ungovernable? And you question yourself, well, what really does need to be governed? And what does it mean to govern something? Like, what does it mean to enforce possession? And it's just these things that you would never think of in your life, and suddenly you're kind of, it's just an interesting,
I couldn't agree more, right? And as someone who's primarily interested in the regulation of ownership, or really the meaning of ownership in intangible goods or knowledge goods, I really got interested in the crypto space, and I'd known about it for a long time. I mean, the Satoshi white paper came out while I was working as a lawyer at Sullivan & Cromwell on Wall Street. I remember hearing about it right at the very, I only wish I'd bought some Bitcoin back in the day, but I was like, wow, that's kind of cool, but not really my area. So whatever. I got interested when the NFT market came out precisely because I saw it was really interesting to me as a new space in which people were thinking about intangible assets in a new way and thinking about what it means to own intangible assets in a new way. And one of the things that made me really interested about the NFT market, and about the crypto markets as well, to agree, was they made a lot of people really upset in ways that those people couldn't articulate, right? And in particular, the NFT market made a lot of people who I spend time thinking about really upset, namely kind of artists and illustrators and other people who are involved in the production of different kinds of works of authorship. Some people were really excited about it, and other people were really angry about it. And the people who were really angry about it often couldn't really articulate what exactly it was that made them so angry. And so that, that was sort of piqued my interest. That's the kind of thing that's the kind of tell that makes me think that there's something here I should be paying attention.
Well, it feels like, I think in that world, it feels like there's a competitive, people are getting a leg up just by having a specific type of knowledge, or like an ability to tap into a market. I hate to use the phrase access, but it's, can't think of two different worlds of technology and artists, that some people are just, that's not their world, and they lose access to a market. It probably feels like an unfair advantage in some way, but
I think that's
move so quickly too. Like a lot of people have to jump in feet first just to, to be first.
Yeah, I think that's all true. I also think that one of the things that made a lot of people really upset is that they saw, in a way that they couldn't fully articulate, a kind of harbinger of change in a market that they thought they understood. And I think that really kind of is a nice way of kind of foreshadowing what you wanted me to talk about.
Yeah,
today,
you're getting, I like to just ramble a lot, so you're like, you keep me on, be my rudder here.
I
bring in on that, but I don't want to talk enough. So
yeah, for me specifically, what the NFT market did in a lot of ways was suggest a kind of transition or the potential for a transition in the market for a lot of works of authorship from a primarily copyright-based scarcity model to a primarily trademark-based kind of clout model, as it were. And I think a lot of people were really uncomfortable about that because they're used to thinking about the market in which they operate in one way. And when they see a change, it's disconcerting to them.
Right. Yeah, exactly. I'm trying to pull up the tweet that kind of triggered why I wanted to talk about this. Do you have any questions, Emil, while I'm looking at this? Sorry, I'm kind of...
Well, you were involved in some NFT projects yourself, right?
I was, yeah. So,
you can't shill. This is a no shill space.
No, absolutely not. I have nothing for sale at the moment, so you can only buy in the secondary market. But yeah, so I was also a securities lawyer before going into NFTs. Before going into IP law, and so when the NFT space kind of broke, it was really interesting to me that a lot of people were worried, and I think with good reason, about whether or not they might be subject to regulation for selling NFTs under the securities laws. And so, I started thinking about, well, how can I sort of interact with that concern in productive ways? And so one of the things that I did was create an NFT project that was a kind of deliberate effort to provoke the SEC by explicitly securitizing a project and characterizing what I was doing as a sale of an unregistered security. So what I did was create a conceptual artwork titled SEC No Action Letter Request. And the conceptual art consists of sending a no action letter request to the SEC, proposing to sell a work of conceptual art that I characterize as an unregistered security, and then kind of tell the SEC that, look, this is why what I'm doing is something that you say you should be regulating. Therefore, you should regulate me and tell me I'm not allowed to do what I'm proposing to do. The SEC never took any action, but the NFTs did sell pretty well. Made about 40 grand off that one. And I bought my wife a Mustang GT. So that was
nice.
Right on.
The car that NFTs bought, as it were. And actually right now, Jonathan Mann, Song a Day Man, and I are actually suing the SEC in the Eastern District of Louisiana for a declaratory judgment stating that selling art as NFTs is not a violation of the securities laws. We were actually supposed to have a oral argument on the SEC's motion to dismiss last week, but the court has postponed that for another month and a half or so. So
they really have kicked this crypto can down the road a long time, right?
Yes, they
it's
have.
Weird they want to be so vague for so long. Maybe that's part of the tactic.
Well, I mean, I think it was. I think the vagueness and the lack of transparency was in part a reflection of the Biden SECs of the kind of the chairman Gensler at the SEC's perspective, and a sort of broader take within the sort of Democratic Biden White House that this kind of whole crypto thing was undesirable, and therefore they should kind of try to tamp it down as much as they possibly could. And so kind of not telling people what they could or couldn't do, not developing kind of regulations that would enable people to more kind of easily create and sell projects, kind of creating that kind of regulatory uncertainty is a way, whether it's a bad way, I think is debatable, but it's a way of discouraging.
It prevents investment.
Yeah, to slow down
time,
the
money.
market. Yeah. But so I'm curious as to what, in terms of blockchain and NFT, would constitute a unique intellectual property that's patentable, right?
Right.
There's
plenty of patents involved when it comes. Well, it mostly be like software patents would be at issue. So different ways of creating things on the blockchain, different ways of selling things on the blockchain. I mean, a blockchain technology in theory could be patentable, although I'm not sure how relevant patents really are in that space.
Like Bitcoin's open source, so you can't patent at that point, right? Once it's made open source, it's kind of.
Yes, that's true. Right. So, I mean, the way patent law works is it goes to specific inventions and discoveries. So what you're doing is disclosing to the government that you've invented or created a new thing, and you claim exclusive rights to use that new invention for a period of time. Right. So when, for example, Satoshi, whoever Satoshi is, invented the Bitcoin blockchain, to the extent that the Bitcoin blockchain was different from any other blockchain or anything else, any other sort of internet-based crypto platform that had previously existed, in theory, there's the possibility that Satoshi could have said, I created this new thing. No one's ever done it before. No one's ever done it the way that I'm proposing. And I want to claim a patent over this particular method of encrypting information on a blockchain. Right. And if he'd done so and other people use that same method without his permission, then they would be infringing. He could stop them. But of course, that was contrary to his goals. Right.
Well, you couldn't truly stop a copy anyway.
Well, I mean, maybe not, maybe not. But
ideally, if you can't stop Bitcoin, how could you stop a copy?
Well, but you could go after whoever created a new blockchain. If you could identify who that person was, and you could say you've engaged in patent infringement, and if you generate any revenue from this infringement, then you have to pay it to me, or you have to pay me damages for having used my patent without my permission. I would have licensed it to you. You didn't pay for a license. You owe me a licensing fee. Plus you owe me penalties on top of the licensing.
But so like a MicroStrategy, for example, can't retroactively patent Bitcoin's technology. No. They can certainly build on top of it and create their own protocols for whatever identity I think is what they're after.
That's right. That's right. And if they create a new tech protocol on top of an existing protocol, right? And I'm not an expert on this kind of stuff, so I'm just going to speak in vague generalities, right? But if whatever new protocol they developed is new and not obvious, and no one has ever done it quite that way before, in theory, they could file a patent application with the United States Patent and Trademark Office and say, this is this new protocol we've developed. We think it's novel and non-obvious, and we would like you to issue a patent to us for that new protocol. And if the USPTO agreed, they'd issue them the patent, in exchange for paying fees and blah, blah, blah. So, yeah, I mean, you can patent any kind of new development, even if it's a relatively small kind of new change or new addition to something that's existing. Now, if there'd been an underlying patent, they would have to be concerned about like their use of the underlying patent. But because the Bitcoin isn't patented itself, they could build on top of it. And there are plenty of people who filed blockchain related patents, whether or not they're enforceable, in practice, whether or not they're valid patents. I have no opinion. I'm not so much of a patent.
Right. So it is extremely interesting. Well, so let me just kind of go, and I know we've been talking about it, but I think this is what brought this up is, so Jack Dorsey, the founder of Twitter, interesting guy. He's a Bitcoiner, and he says his post is delete all IP law, and it got 12 million views. There was a lot of conversation. It's fleeting. This was like 8 days ago. So, April 11th. Yeah, exactly 8 days ago. So it's it's amazing how something can be interesting for literally 6 hours on Twitter, and then it's something else comes along. But this guy, I don't know if I follow him or not. Yeah, I do. But libertarian, agreed, burn the entire regime. The moment you do, innovation will explode. This is the argument that I find a lot. Culture will accelerate. Technology will evolve in real time. Ideas will stop being hostage to legal fiefdoms and start flowing like code in open source. I mean, this sounds a little bit, this is some grandiose terms. It doesn't protect creators. It protects gatekeepers. It's not about rewarding genius. It's about bottling it, branding it, and turning it into rent-seeking monopoly. It would unleash a real engine of progress. Yeah, iterations, mixing. Okay, and then
the next reply is like the obvious counterpoint to that, right? How do you protect individual artists from their work being appropriated by or consumed by an AI model?
Well, it's something you said interesting there is that you can get patents for. Well, let's because actually this before we get on. There are 4 types of patents or IP protection.
So this is the thing, right? IP or intellectual property is just a blanket term that we use to describe a whole bunch of different, totally unrelated bodies of law that are intended to protect very different kinds of things for very different reasons, and they do so in very different ways. So the kind of the most important or significant kind of bodies of law we usually put into the IP basket would be patent, copyright, trademark, right of publicity, and trade secret law. There are some other things that we might consider also kind of forms of IP, but those are the 5 kind of big ones that are kind of the when I teach a survey class, those are the ones.
What was the 5th one again?
Trade secrets, right of publicity, copyright, patents, and trademarks. And really, it's patent, copyright, trademark are the big 3, as it were. The other ones are important, but maybe kind of less significant, and especially in kind of thinking theoretically about how intellectual property doctrines work. The one thing that they kind of have all in common with each other is that they protect exclusive rights in intangible goods, right? In other words, we often call them like knowledge goods, as it were, right? And the big difference here, right, is when we think about property, normally we think about exclusive rights in things that are scarce, right? Things where there's only a small amount, things where when you consume the good, there's less of it left over after you're done consuming. The big difference with IP goods or knowledge goods is that they're intangible, which means they're not scarce, right? Which means when you consume them, the quantity, the supply doesn't go down, right? You don't use them up, as it were,
right?
The way you do with other kinds of goods. So I mean, if I've got an apple and I eat the apple, no one else can eat the apple because the apple's gone, right? But if I have a book and I read a copy of the book on the internet, well, an infinite number of people on the internet can read the book at the same time because there's no scarcity of the book or no intrinsic scarcity. So typically what intellectual property rights do is create scarcity where there previously hadn't been any scarcity, right? So when we create a copyright, for example, we say, well, this work of authorship would normally be non-scarce or non-rival is the term that a lot of economists would use. It would be a public good, and anyone who wanted to consume it could consume it. And that would be great, right? Because we want people to consume works of authorship. They derive social value from that. They derive welfare from that. It's good for them, right? To consume whatever it is that they enjoy consuming. They derive utility therefrom, right? But we say, well, we're going to create exclusive rights in that work of authorship, in that book. And we're going to allow the owner of those exclusive rights, whether that's the author or somebody the author has sold those rights to control people's ability to consume this work so that other people will have to pay them typically to consume the work rather than being able to just do it for free, right? And the reason we do that, at least in theory, right, is that we think that while it would be in a kind of static sense good for consumers to be able to consume works of authorship without having to pay for them, right? Because they're non-rival, they're not being diminished by use.
Right,
There's no reason for people not to consume them. They're public goods. But what we're worried about is dynamic efficiency, right? We're worried about the production of these works of authorship in the future, right? So the reason we create these bodies of intellectual property law is in order to regulate for the future, in order to encourage or incentivize people,
right?
Create more of these public goods that we think are really valuable. We think of it, we often call this the intellectual property or quid pro quo, right? The something for something, right? So it's
Mm-hmm.
the public gives individual authors, inventors, businesses, certain kinds of exclusive rights over the intangible goods that they produce in order to encourage them to produce more of those goods in the future. And the sort of premise of intellectual property law is that the value of the future goods is higher than the cost to the public in the present. In other words, at the end of the day, the public is actually getting a better deal because by imposing a cost on itself through intellectual property law, by giving exclusive rights and then paying to use the works of authorship or the inventions that are produced, you get more works of authorship and invention, and the additional works of authorship, the additional inventions have more social value than the social cost of providing the protection.
So it's like it's almost like this necessary violation of the free market because you're viewing it as a betterment long-term culturally. Like if we're talking about copyright laws, right? It's like funding research instead of funding scientific research,
Mm-hmm.
it's funding
That's right.
Writing research or art research, but you're doing it like in a odds free market way.
Bingo,
right?
bingo. That's exactly right. Right. So we have two options. We want to encourage investment in the production of public goods like this, production of knowledge goods. Well, there's two ways of doing it, right? We can do it directly, right, by giving grants or funding directly to the people who we want to have produce these new things, or we can do it indirectly through intellectual property rights, right? And we do this directly, right? The government gives out lots of grants to universities and elsewhere to encourage the production of new inventions and discoveries. The government and private organizations give out lots of grants to authors to produce all manner of kinds of authorship, but we don't think that that's as efficient as it could be because the problem is it's really hard to know who to fund. Right. Sometimes
you don't know what people want, right? You don't know what
people want. You don't know who's going to be productive, right? You might know that somebody's going to produce a work of authorship, but you don't know whether consumers are going to want to consume it, right? And so in order to solve that knowledge problem, as it were, the fact you don't know who to fund, you do it indirectly instead. And you put the burden, you put the risk onto the producers rather than onto the intermediary, rather than on the government. And you say, well, if you produce things and they turn out to be valuable, then you can internalize some of the value of the things that you produce through intellectual property law. If you produce things that turn out not to be valuable, well, too bad for you, right? That means you don't get to consume anything or you don't get any value out of them because you chose to invest in producing something that turned out not to have any social value. So it kind of turns the investment into the production of knowledge goods into a kind of gamble for the producer.
Yeah.
I think you said something else that's really important, right? Which is that fundamentally what intellectual property rights are is a form of regulation, right? Mm-hmm. What we're doing is adopting a body of regulatory law intended to achieve certain kinds of social outcomes, right? And the reason we do that is that we think we can actually solve market failures through that regulation. In other words, we think that there is a transaction cost of some kind. There's some kind of deadweight loss here that's being created by a market failure, right? That in the absence of intellectual property law, people have insufficient incentive to invest in inventions. They have insufficient incentive to invest in the production of works of authorship. And therefore, we're going to get a suboptimal level of production of inventions and of works of authorship. And by engaging in this regulatory intervention, by creating bodies of intellectual property law like patent and copyright, we give people an incentive to invest in these areas where we want to see investment, to invest in innovation. And as a consequence of that increased investment, we solve the market failure, or at least we reduce the market failure and increase
I think there were, in my lifetime, there were two instances. Oh, sorry, I think you got off me. I was saying, in my lifetime, there were two instances where IP law and copyright law were brought into the public sphere of discussion. First time was with Napster, and that, the fact that people were just pirating songs.
You pirate.
Yeah, well, that's it. Technology enabled people to skirt traditional copyright gatekeepers, right? Mm-hmm. And so they had to create something called the DMCA, the Digital Millennium Copyright Act. And today, I mean, it's the conversation is back in the public sphere because of things like AI and OpenAI and them just ingesting everything that's available to them on the internet to train their models. And so I guess that's what Jack was referring to. I guess he wants open access to information for the language models to improve
Yeah.
their capabilities, right?
Yeah, so I think you asked some really big questions there actually, and I think they kind of fall into two categories, both of which have to do with the intersection between the production of works of authorship and the development of new technologies, right? So I'll start by talking a little bit about Napster because I actually think it's a really great example of how that works with a kind of long historical pedigree, right? So as you say, right, Napster was a tool that enabled people to share songs primarily, but in theory, you could file share anything over the internet. Effectively, it was a tool for copyright infringement. It was a way for people to get digital copies of works of authorship that they would otherwise have to pay for. But it was a new technology that was really useful in a lot of ways. And actually, the reason Napster and other file sharing sites are largely not relevant anymore is that the owners of the works of authorship in question have moved to a streaming model instead of a paying per copy model, right? And the irony is, right, that they could have done so in the Napster era as well, right? They could have started streaming stuff. They could have done a Spotify in response to Napster, and Napster never would have caught on because it turns out people prefer streaming to downloading and owning in a lot of ways. What they want is access, and they don't care about owning the actual copy. They just want to hear.
And that's a whole nother conversation.
Right? And so, but this is an interesting long conversation because this is a story that's happened over and over again. Right. So, back in my childhood, in the 80s, right, the big argument was over the VCR. Right. And when the VCR was introduced,
and mixtapes, right?
The president of the MPAA said this is like the Boston Strangler for the film business. Right. The VCR is going to kill the film industry because now people will be able to tape stuff and watch it at home. They won't go to the movies and buy tickets anymore. Right. We're all going to go out of business. Right, because of this horrible new invention. So you got to stop the VCR, Congress. You got to prevent.
Every bodega was selling bootlegs, right?
Right, yeah. Right. But it turned out, right, that they were so scared of this new technology that was going to upend their business model. It turned out that the VCR was the best thing that ever happened in the movie business. Their profits just skyrocketed. Right. Well, exactly the same thing happened with Napster. Right. Napster comes along, file sharing comes along, and the film and music industries, which historically have been in the model, are in the business of selling particular copies, physical copies of music and films. Right. They're like, oh no, this is terrible. Now people can share this content on the internet without having to go out and buy a copy. How are we going to make any money? We're going to go out of business, right? Because we can't sell copies if people don't want to buy copies. This is the worst thing ever. You've got to prohibit this. You've got to stop people from doing this. When they finally came around, when Daniel Ek kind of convinced them to eventually license stuff to him to put it on Spotify and distribute it that way, they realized, oh, wait a minute, people just want to consume this stuff and they're perfectly happy to pay for it so long as it's easy. And what was the net result? Well, once again, this technology they thought that was kind of existential for their business model turned out to be a huge boon. And now they're making more money than they ever made before, right? So once again, they were tooth and nail opposed to this new technology. And then when it finally, inevitably, I think, caught on, they realized that, no, actually, this is great for us because it just means even more consumption than it previously existed. And I think that part of what that reflects is the fact that producers often don't see that the demand for these intangible goods, for these knowledge goods that they're producing is even higher than they realize because consumers are so responsive to transactions costs, right? The cost associated with getting a copy.
Well, it makes you think what they probably didn't realize is they're in the distribution business, right? They're not in the music creation business.
Right.
And so creators want to just create, consumers just want to consume. And so I would say in my business world, do well what you do well. Don't try to be all things to all people. But it kind of brings up, because this is one of the things this idea of abolishing IP law. The reason that the music industry, those companies continue to be the leaders in their industry is because they are the leaders of the last iteration of this industry. So they're well funded. And they have a very serious advantage over somebody trying to just build their own streaming site or something like that. And if you abolish IP law, again, I'm maybe being a doomsdayer here, I would see it as the winners of yesterday are going to continue to be the winners of tomorrow because they already own the physical. If we're talking about physical things you're going to create, patents. If I own a factory, I'm going to be able to spin up your idea a lot faster than you are because you don't own a factory today. So why would you invent something if you know it's just going to be taken by the existing powerful and produced at a fraction of any cost you could ever make in days rather than, you'd be years behind developing that thing.
Right.
So it would bring good ideas to market faster, but it would squash good ideas. So you run out of good ideas, right? Or, I mean,
it's like, are the artists still benefiting, or is it just Spotify now that's making all the money?
Well, I think it's a little bit of both, and it depends on the artist, and it depends on their deal with their label, primarily, right? So, in a lot of cases, artists complain about not getting paid very much when they stream on Spotify. Part of the reason for that is, each Spotify stream just isn't that lucrative, right? So you have to have a lot of streams for it to be worth anything. Part of it is, if you have a label and you have a kind of a not particularly favorable deal with your label, the label might be collecting most of the Spotify revenue from whatever it is that you recorded for them. But that's between you and the label. That's not Spotify's fault if you cut a bad deal. But to get back to what Grant was saying, right? I mean, what I really think is important here is to remember that we're not talking about IP law in general. We're talking about different bodies of law, right? So specifically here, if we want to talk about copyright law, right? Well, I think that the point is to ask, what do we want to achieve when we do copyright law in any particular space? What do we want to accomplish? And then we can ask, well, right, is the regulatory activity we're taking that we're engaging in, is the way copyright works in this space accomplishing what we want to accomplish or not, right? So I would characterize it not so much as a kind of abolish copyright law. There are reasons to, they're coherent, although maybe not.
Can I ask this? Like, have these IP laws existed since the founding of this country?
Well, okay. So the Constitution allows or explicitly authorizes Congress to create patent law and copyright law, and both of those existed in England before the Revolution and in other countries to varying degrees as well. And Congress immediately created patent law and copyright law.
Can I ask you even further back? Like, when's the first concept of protecting an idea?
That's a great idea.
Yeah, this is a question that a professor loves to hear.
Yeah.
Tell me about the first patent.
Yeah. So the first forms of patent law were developed in a kind of piecemeal fashion, largely as a function of the kind of very, very early beginnings of the kind of transition into modernity, right? So as it became the case that industrial production and distribution of manufactured goods became over long distances, right? As trade became increasingly important and trade in manufactured goods became more important, control over the production of those manufactured goods and over new inventions became increasingly valuable. So most people think that the sort of initial versions of patent law were sort of developed in Venice, arguably around Murano glass and other kinds of inventions that were happening in Venice, which was, the largest trading kind of.
Like right around the same time, like central banking came around.
Yeah, well, I think some say banking maybe even a little bit earlier, but yes, largely, right?
Okay.
Copyright law was a kind of offshoot or a byproduct of the invention of the printing press. Right. So prior to the invention of the printing press, the primary cost associated with reproducing works of authorship was handwriting them. Right. Like creating the work of authorship was really expensive. There was no real need to have exclusivity over the work of authorship contained because all the cost was built in. Just really quick, I went somewhere, I forget, it was some sort of museum or something. They were talking about the printing press. Yeah. They said like the year before, up until the printing press was created, there were something like 600,000 copies of the Bible had ever been created in the history of time.
And in the year it was created, it was like 60 million got created. Like just some number where you're like, holy crap.
Yeah.
What
Well,
an
so
invention.
this is the thing. The reason that the printing press was, the reason it caused, or reason it led to the invention, incentivized, as it were, the invention of copyright, was that the printing press dramatically reduced the marginal cost of printing copies of a work of authorship. In other words, the cost of printing of making each additional copy went way down. Didn't go cheap still, but the cost went way down. But it increased the fixed cost of producing works of authorship. In other words, you had to invest a lot of money up front because a printing press only makes sense if you're producing a lot of copies. It doesn't make sense for producing one. So handwriting one copy of the Bible is cheaper than printing one copy of the Bible, but printing 1,000 copies, each copy is way, way, way cheaper than one handwritten copy. So the thing about the invention of the printing press was it meant that that printers had to invest a lot of resources in producing copies of a work of authorship, and so they had a really high fixed cost, and it was uneconomical for them to make that investment unless they could have exclusivity over the market, because otherwise the concern, and I think a realistic concern, was that their competitors would just wait and see what other people printed, right, and see if it was popular. If it was popular, then they would print it too and compete. If it was unpopular, then they wouldn't print it.
Right. Yeah.
So the concern was, well, how do we regulate the market such that the printers can have exclusivity and therefore invest with more confidence in producing multiple?
Yeah, you don't want everybody to be scavengers, right? You know, just like feasting on the ideas of others.
That's right. So the initial, but really the idea was that we want to encourage printers to invest in printing books because books are good and people want to consume books. And if we don't give them exclusivity, they won't print as many books as we'd like them to, right? And actually, once again, right, copyright wasn't invented in Venice, but Venice developed the sort of earliest kind of full-bore regime of regulating the production of printing privileges.
Sorry,
and that would have been in the 16th century.
So like on its surface though, like almost, I can't imagine somebody thinking that, okay, this guy wrote a book, who cares? We shouldn't. I think most people would say, yeah, of course. I mean, you should be rewarded for your idea. You went and did something. You have a song I love. Of course, I'm going to pay you for it. And it would be really, I mean, gosh, we see it on the internet. People get mad when someone steals a meme, right? Because there's some possession there. So I'm like, hey man, I thought of that, you know?
Sure.
And monetization of memes, that's something we don't have. But but I guess the question is like, what? I can't even imagine the case to say that we should abolish the ability to protect your intellectual property. And I think I asked just a little bit before we got on. Has there been a growth or an expansion to the point that maybe there are some areas where it doesn't feel so logical anymore? You go, wait a minute, you shouldn't be able to protect yourself from this or that. Like what are maybe the grayest areas, or where maybe what Jack is generalizing his anger or whatever, his idea at something, when maybe it's just a few portions of IP law that he finds offensive, the ones that probably impede his business model, I would imagine.
Right. Well, I think what you got to do is think about this in two different ways, because I think people have two different ways of conceptualizing what specifically copyright law is for. So on one level, there's the kind of economic utilitarian view of copyright that I've been describing. It's just a regulatory tool for encouraging investment in the production of new works of authorship. And we can just evaluate whether or not it's economically efficient in determining whether or not we like the way the regulations are working. But there's also what we call kind of a more deontological or moral view of copyright, which says that people are entitled, somehow metaphysically entitled, to own and to exert control over the works of authorship that they create, whether that's because of their investment of labor, whether that's because the work of authorship is a reflection of their personality and personhood, right? However,
and just like you would want to reward the guy who figures out how to efficiently chop wood, you'd say, well, let's make that his best thing. So the people that are good at creating ideas that people love, you want to encourage, you want them to keep doing it because that's good for everybody, right?
Absolutely. But I think that, that kind of mixes a little bit of the two, right? That it's good for society if we encourage this person to do what they're good at by giving them some exclusivity, and it's the right thing to do. We're recognizing their contribution in an appropriate way. And this actually comes back a little bit to the question you asked me before, like, where did intellectual property law come from? Well, I would argue that on some level, the earliest form of intellectual property law is the concept of plagiarism, right? Because the idea of plagiarism is, you can characterize it as a rule of mandatory attribution, right? Which means it's a obligation to attribute a particular work of authorship to a particular person. Now, that's a pretty thin form of copyright, but I think it's kind of a version of copyright, or at least kind of a version of ownership of a work of authorship. And we can trace the concept of plagiarism all the way back to the Roman Republic and ancient Greece, right? So the term,
in today's world, right? Like where you remember last week we had these Studio Ghibli memes, right, that were popping up all over X. So it's cool if an AI model ingests these things, right? Assuming they have to pay a license fee to do so, probably some kind of corporate license fee that's higher than what you and I would pay for a movie ticket. But okay, so they ingest it, and then their works are now derivative, right? They're creating new derivations of art based on Studio Ghibli's style. How does how does copyright work into that? Is that like?
So this is a really interesting question, and I think one of the reasons, well, there are two different things going on here, right? And I'll talk. I think, I'll talk about them separately, right? So from a purely doctrinal copyright law perspective, AI models are a problem, right? Because copyright doctrine doesn't really have great tools to think about them, right? Because they work in ways that copyright law doesn't really anticipate, right? So when we think about the relationship between copyright and AI models, there's, I think, really deep questions about whether AI models are infringing, either on the front end or on the back end. And I think the more important question really is whether we think it should be infringing for AI models to the way they interact with copyrighted works to be infringing. Again, whether on the front end or on the back end. So I think there's really two big copyright questions that are posed by AI in relation to infringement. The first is, does training an AI constitute infringement? And the second is, can the products of an AI model be infringing? And if they are, is the AI model or the owner of the AI model liable, or should they be liable for that infringement?
Like, can these memes be copyrighted by Studio Ghibli? Right? Like,
probably. I mean, it depends, but probably not, right? Because the reason we call it Studio Ghibli is because it looks like the Studio Ghibli style, but copyright doesn't protect the style, right? Anyone can produce new works of authorship in the Studio Ghibli style, and if they do so as the producer of that work of authorship, they're the copyright owner of that work of authorship, and Studio Ghibli has no claim over that. No copyright claim over that. In theory, they could have like a trademark or trade dress claim for producing something, but that would only be if you said to other people, "This is a Studio Ghibli product," right? Or let them believe it was a
pass it off as that branding.
Yeah, if you engage in a trademark violation, okay, maybe. But from a copyright perspective, that's non-infringing.
So like, just like people make a shirt with the Coca-Cola script, as long as it doesn't say Coca-Cola. Or claim
right. As long as a reasonable consumer wouldn't believe that the source of that product is Coca-Cola or Studio Ghibli, then there's no trademark infringement, and therefore no problem there.
Dude,
right?
this is like an infinitely interesting topic to me.
Yeah.
So layered. 'Cause I'm thinking about the AI models. What they're doing is they're going, well, the computer did it, I didn't do it, but they are monetizing the whatever that thing produces.
Yes, yeah, but the thing is what the AI model is doing is analyzing a whole bunch of different works, right, in order to find relationships between the parts of those works, right? It's essentially a machine for finding deep patterns about how people create works of authorship of different kinds, that kind of reverse engineers them and uses them to generate new works of authorship that are similar to previous ones that have already been created. And the irony of the kind of the training issue, right, is that merely consuming the work of authorship itself, that isn't infringing, right? We call that a private.
As long as you paid for it, whatever
but
charge are supposed to be charged. Yeah.
I mean, if you have a copy of a book and you reading it 2 or 3 times, you don't have to pay another fee every time you read it, right? There's no exclusive right to control the use of the work of authorship once you have a legitimate copy. The only real question, that the copyright question posed by training an AI, is that there's, technically speaking, a necessity to create a digital copy, typically, in order to train the AI. Now, that digital copy isn't copied into the AI model. All the AI model is doing is analyzing the relationships between the parts of the work that is being trained on.
It is shaped by that, though. It is shaped by the media, and like it is not the same after.
But importantly, not in a copyright relevant way. Right? Because none of what's being copied are the actual parts, the actual expressions.
That would be like
as a human being, when you see when you watch a movie or listen to a song, you're forever changed after, right? And everything you do after that is derivative of what you've.
Well, but not in a copyright sense. Not in a copyright sense, right? So when we say something's a derivative work in a copyright sense, what we're saying is that the new work contains a copyrightable element of the previously existing work.
Some sort of significant element to it. Yeah. Okay.
Some element that is sufficiently original to the original work that we think it would be infringing, right? And mere similarity isn't necessarily enough, right? You actually have to copy something about the original that makes the two works substantially similar to each other. So that brings us to the second question, which is on the back end, right? Obviously, people can use an AI model to generate new works that might be infringing on previously existing works. As everyone knows, it's not too hard to get an AI model to produce something that, if produced by a person and sold commercially, would be an infringing work, right? So can that be infringing? I think the easy answer there is yes, right? Is it possible for an AI-generated work to be infringing of previously existing work? Absolutely, in the same way that any other work that you generate could be.
So what do you think Jack's motivate? Like, what is it, the thing that he's seeing that's saying, I gotta make you think like Jack Dorsey here for a second. Is there some major speed bump that AI is having that?
Well, I mean, I think he's probably thinking in part about AI, but I think he's also speaking to a mindset that is much broader and has existed for quite some time. A kind of often people call like a free culture type mindset. And I think the observation there is that, as I said earlier, right, the reason we created copyright law in the first place was as a regulatory regime intended to make the market in works of authorship more efficient. And if we take that model of copyright, then it implies, or it follows, that we should be evaluating the regulation we're doing to see how efficient it is. Right? Like, how much is it encouraging people to invest more in producing works of authorship? And are there cases where it's imposing costs rather than creating benefits? Right. And so we should kind of
discouraging creativity where it's having the opposite effect what we originally.
Let's think about it, right?
And in law, no offense, and lawyers can get into the weeds in cases, and like you just said earlier, like I did this case just to see what would happen. Like sometimes we start shaping the law over time, right? I'm sure
and think about the nature of the copyright regime we've created. If you start thinking about the details, right? Well, copyright, what does it apply to? Essentially everything, right? It's automatic, right? How do you get a copyright? You automatically get a copyright every time you create an original work of authorship, right? So we're recording a video right now.
Right.
When we're done recording, you guys are going to own a copyright in this video that you just created. Whether or not,
like, without a official whatever, if somebody tried to monetize it, you could always make your case. I was the original creator.
No, I mean, I'm saying as a copyright law essentially says that you two are co-authors of this video that we're creating right now, because I'm not participating in the recording. Right? You guys set it up. You guys are recording it. You guys are the copyright owners of the video.
I'm gonna need you to send me a few dollars for.
But the point is, I suspect you didn't even think about that, right?
Yeah, no, for sure.
But was copyright motivating you to create this video? No, because you're motivated by all kinds of other economic and personal factors that have nothing to do with copyright. Every tweet you send, every Instagram photo you post, every Facebook post you make, every email you send, they're all protected by copyright automatically, whether or not you want it. Right?
This is so wild to me. So, like, what about people that, like the guy last week, we shared a video of this guy who it was kind of a heartwarming story. He went to barber college. He was just proud of himself. We just like to promote stuff like that. And I actually went back. I've been talking to him a bit on TikTok, and he's like, dude, I've gone viral in a way, right? He's like, I don't know how to handle it. I got thousands of messages coming in. And there are probably people taking his video, putting it on the newscast. They're putting it on, or got even worse. Some people end up on TMZ, or they become a meme, and it gets monetized infinitely by YouTube streamers and all that. How does somebody claim it? Like, how do you even capture something like that?
Well, okay, so here's an example of that same question, right? I mean, if the idea behind copyright law is we want to give people an economic incentive to create a work of authorship, right? Well, then we should be asking, how much of an incentive do people need, right? This guy created the video. Did he have any expectation of going viral or making money off of it? No, he created it anyway, though. So if he didn't need an incentive on the front end to create it, what's the social benefit in giving him some sort of exclusivity or claim over profits generated from it in the future, right? We didn't need to give him those additional profits. Should we, right? Does he have a sort of existential or moral right to internalize some of that value to some of those profits, even though he would have created the video anyway?
Yeah,
I don't know, maybe.
No, you're right. And will people create even without that incentive? Of course they will. Right. But is there
because again,
you need protection of an industry.
If our theory of copyright is the reason is copyright is justified is because we need to give people copyright in order to incentivize them to produce. Well, if that's true, if that's our theory, then it would actually be inefficient and wrong to give people copyright protection and copyright incentives that they don't want or need. Right. And so what does that tell us? Well, that's an argument to make copyright narrower. It isn't an argument to eliminate copyright.
No, because think about like a tweet, tweets can go viral, and Jack lives and watches people produce content all day with no expectation. And he's monetized that activity since the day he launched Twitter. You know what I mean?
But think about it. By contrast, right? When a movie studio makes a film, right, they're investing millions or hundreds of millions of dollars in producing the film, right, because they expect to make a profit on the back end by selling or streaming or otherwise using copies of what it is that they produce. Does the movie studio need a copyright incentive? Hell yes, right? Because they're investing a lot of resources in producing a good that they think is going to have economic value in the future. So is copyright good at incentivizing movie studios? Absolutely. Is copyright good at incentivizing tweeters and Instagrammers? I'm not so sure, right?
Right. Yeah, probably not. It's not even a part of their mind.
It's not really.
They're going to monetize something. They're monetizing their content in a different way.
That's right.
And actually, the spread of their content is good for them because it grows their brand, right?
That's right. That's right. And so then part of it is if we create stronger copyright protections for those kinds of works, it means it's harder or more risky for people to circulate those kinds of works, which means it's less likely that the person is going to go viral, right? Because people are going to be less likely to circulate it, which means that all the value that they want to claim might actually just evaporate. It's kind of a, killing the goose to lay the golden egg.
Yeah. Don't look a gift horse in the mouth.
Right. So part of the idea behind we should have less IP protection is that it reduces transactions costs on people circulating works of authorship, which encourages them to circulate it more, right? Which means
to the benefit of the distributors.
Sure, but it redounds to the benefit of the brand of the person who's being distributed. Brands are valuable. Brands come with commercial goodwill, right? If you're an influencer, you want people to circulate your content as much as possible because what you're monetizing at the end of the day is your brand, right?
But I think, and most people know that, so they don't actively try to enforce their copyrights,
right?
Which tells me that.
But the thing is, copyright exists. And copyright imposes transactions costs on people using works of authorship, whether or not you're enforcing them, right? So if I'm someone who wants to use a video, I might be worried about potential copyright infringement if I use a video without someone's permission, even though I suspect they might want me to use it in that way, right? And it's costly. It's difficult for me to contact them and ask for permission. So in a lot of cases, I'm just going to say, well, it's not worth the risk. It's not worth the trouble. I'm just not going to do it. Right.
Yeah, like I think about the videos on YouTube where people play. I don't even understand how they get it. You play 10 seconds of a song, they're going to tell you can't do this. But some people do like reaction videos, and some of those companies do you'll click on a video and it'll just be silence because
so this is an
after
interesting
the
story,
person.
right? So for Animal mentioned this earlier, I think, right? So in the early days of the internet, the Congress passed the DMCA, the Digital Millennium Copyright Act, and the idea was to sort of police copyright on social media, initially on YouTube, but eventually other places. And the initial move of copyright owners, when they saw their songs or videos or whatever being put on YouTube, was to send takedown notices and say, you're not allowed to do that. The only way this is going to be on YouTube is if we put it there or we permit it, and we don't want you using our copyrighted content on YouTube. But then YouTube added advertisements, which generated revenue that went to the poster of the video. And what it did was say, well, if you're the copyright owner and you see somebody using your copyrighted content on YouTube without your permission, you have two options. You can either take it down or you can have the ad revenue directed to you. Well, guess what, right? Now, 99% of copyrighted content just stays up and the ad revenue goes to the copyright owner rather than to the poster.
They all saw everybody getting rickrolled.
Interesting.
They saw Rick Astley get rich again.
Exactly.
And they went, whoa.
Now all of a sudden, they've got a bunch of other people essentially selling their works for them, right? So they turn lemons into lemonade, as it were.
Yeah, there's a guy, Rick Beto. I don't know if you know him on YouTube. He's like an old music producer, and he does videos all the time talking about old music and just analyzing how the song was made, and it's really interesting. And but he has artists that he still this day he's like, why would you not want me to play your song? I have millions of followers. Like, this is good for you, but there's just certain bands or record companies that just don't want it. Like, I know, kind of like Led Zeppelin famously would never let people use their songs in commercials, and you're like, why wouldn't you want like a movie to associate an amazing movie with your song? It's like you're making it a forever moment. But
exactly, and this is transactions costs associated with copyright. And the additional problem, right, is what if on one level it's copyright makes it difficult and expensive to use the works of authorship that you want to use, right? What's more, there's a speech problem, right? So we kind of assume that copyright owners are kind of rational economic actors and using their works in rationally economic ways. They're trying to maximize revenue. But everyone knows that's not true, right? People use copyright to control the speech of others all the time, right? In theory, copyright is about encouraging people to speak. It's about encouraging speech, but it's about encouraging speech by creating property rights in speech. So there's an inherent First Amendment free speech problem, because what copyright does on one level is enable copyright owners to drag in the government into forcing other people to shut up, right? To not use their works in ways that they disapprove of, right? Now we pretend that that's not happening, but everyone knows that that is happening, right? And so then the question becomes, well, how do we square copyright protection of expressive works, right? Works that consist of speech with our commitment to protecting the freedom of speech, protecting people's ability to express themselves. One of the ways we do that is through the fair use doctrine, which says that certain kinds of uses are per se not infringing, right? So you can do those things without the permission of the copyright owners. One of those would be criticism, right? So, copying from a book would be infringing, right? But if you copy from a book for the purpose of reviewing the book, right? Like you say, boy, this author's a real moron, and here's a couple of sentences from their book that'll prove what a moron they are. Well, that they don't like that. They don't want you to do that, but they can't stop you, right?
Okay.
You're copying for the purpose of criticizing the original. It's not a substitute for the original, right? And so they don't have any way to prevent you from doing that. And those kind of reaction videos and whatnot, they're kind of a subgenre. We might call them a kind of like unsophisticated form of criticism.
Right. Yeah.
Right.
Well, sometimes it's not critiquing, it's just listening and enjoying, right? Yeah. Like,
showing a reaction to it.
The fact that people are watching it for the reaction, right, rather than watching it for the original, or at least they're watching it for both, right, says to me that this is the kind of thing where the two aren't a substitute for one another. If I really like a song or I really like a video, I'm going to listen to the song or watch the video. I'm not going to watch this reaction thing, because this reactor is annoying, right? They're getting in the way of me appreciating the underlying thing that I work with.
So there's got to be a way, like, this is interesting, because like blockchain could really be used for a way to sell the right to use, like a one-time use of a song. Hey, $5, click, you get it. And you have some sort of receipt that you could post on the screen, right? That anybody could scan and go, yep, that's a valid. Although then we get into like copying the valid, but make the cost small enough that it.
There are plenty of people trying to work on ways to make that kind of market transaction feasible. I think the mechanics of it are hard, and I think also the kind of market social aspects of it are hard to make actually work. But there's plenty of other people who've had that thought. I've spoken to people who are trying to set up a kind of blockchain-based system of licensing.
Yeah, you need some sort of like revolving validators that you can't constantly, because you can't copy the proof, right? You can't copy the receipt and just have 100 people copy. But even so,
a platform that's unanimously agreed on, right? You need someone to be, I don't know, maybe like an Apple or Spotify to start it off, where they already have.
Why YouTube isn't doing that today? I would think YouTube would love to be the broker on 1 million sales. You know what I mean? Like, think how many sales dollars would come in, and they take 5% of it, and they give a stamp of approval. They regulate how the laws are managed so that they know any video that goes up with content is valid, and that would make the.
Well, I mean, I would say like the AdSense thing that I was talking about. Right.
Yeah.
Where the ad revenue from posting copyrighted content just gets redirected to the copyright owner. That's kind of a version of what you're describing.
Yeah, but it hinders. It does it in a way that doesn't allow for maximum content.
Well, no, but actually, I think on some, I mean, it doesn't allow for the changing of the content, at least as much as we might otherwise want it to, right? But it does encourage people to post more stuff to YouTube, right? Or rather, it reduces the transactions costs on the stuff being taken down, right? Because people are already posting copyrighted content. They might stop if they see it get taken down all the time. But if they see it stay up, then they'll keep doing it and they'll keep doing more of it. And the ad revenue gets directed to the copyright owner. So now the copyright owner doesn't have an incentive to take it down, right? So we do solve at least one of these kind of transactions costs associated with encouraging the distribution of the works of authorship. And again, it's kind of in a clunky way, and it's not as sexy as like a blockchain-based solution might
because I've done a video before and had the song comes up and it comes back to you and says, look, we're going to basically mute this part of the video if you want to keep it up. And to me, if they at that point said, look, you can keep it the same, but it's going to cost you $3 to use this song, I would go, yeah, I'll just pay the $3.
Or how about how about a percentage of your ad revenue?
Right. Unless you have none.
No, but I mean, if you
not
have
naming any names.
if you have no ad revenue, then what's the point in stopping you from using it, right? You're not harming anyone.
Right. You've not monetized anything. Yeah, you're right. Well, so why do they then? Why do they?
Well, it's because copyright is a blunt tool, right? And
they don't want to take the risk. It's not worth fighting that fight.
From the copyright owner's perspective, there's no incentive to make it easy to use their work of authorship. What they want to do is force people to come to them with payment, right?
But you are in a way.
Well, yeah, but
with the AdSense, you are, because you can't monetize. Right. Although, realistically, we have a sponsor to the show. But that's a workaround way.
But again, right, the thing is, copyright owners didn't create the YouTube AdSense model. Google did, right? And it was because Google had an incentive to maximize the amount of content that was being uploaded to YouTube and staying on YouTube, right? The copyright owners individually didn't have an incentive to do that, right? So it took relying on the business that had a financial incentive to solve that market failure, to get the market failure solved. The copyright owners couldn't do it on their own, even though at the end of the day, the copyright owners end up reaping a significant fraction of the benefits, right? They didn't have the ability to coordinate to solve that problem.
Wow.
So they just automated the process.
That's right.
I feel like we were talking yesterday and we're like, oh, well, how long are we going to be on? I'm like, maybe an hour or something. And I think we just, in an hour, I feel comfortable with copyrights. I haven't even gotten to patents or any of this other stuff. I know you got to go soon.
Yeah, I got to run and listen.
I feel like this is just an infinitely interesting conversation, because it's so much, the law is so much about language and interpretation of intent. And yeah, like you're talking about, are we getting the net result of the initial spirit of the law, or has it been twisted in a way that's produced something we don't actually want? And yeah.
Well, and I'll leave you with this. Another thing that Jack might have been thinking about, right, was the fact, how long does a copyright last? Well, currently the default copyright term is the life of the author plus an additional 70 years. So really the answer is it might as well be forever, right? Is that efficient? Do people need a copyright to last for 100 plus years in order to have an incentive to produce things, right? Most things are going to be forgotten next week, never mind 100 years.
Yeah, maybe 15 or 20 years. Think about a career, a job you would have 10 years. That's a long, okay, you got paid 10
years. Initially back in the 18th century, right, when copyright was first created in the United States, the term was 14 years, and you could get an additional 14 years if you wanted to. In other words, if the work was still valuable after 14 years, you could renew it and claim another 14 years of protection.
What triggered the length of time? Corporations trying to protect ideas for...
Copyright owners who kind of hit the jackpot turned out produced something that was really popular, and they wanted to continue having exclusivity because people were still consuming the work many years in the future.
How is it that the creators of the Constitution got everything so right, and we've just made it worse over time? You know what I mean? They do minimal law. They wanted minimal infringement, but they were very selective about when they chose to bring the government into play.
Yeah. Well, I mean, I think it's when people had economic interests and when additional exclusivity, when additional protection redounded to their benefits, they would go to the government and lobby the government to add new things to the Copyright Act, for example, in order to give them more protection, which really meant more way to extract value from whatever work it was.
Protect their ideas. Yeah, I mean, the idea of a corporation itself, right? It's protecting.
Well,
it's protecting themselves from competition is really
and copyright policy is pressed by authors as much as by companies and distributors, as much as by the middlemen, right? In part because I think authors have internalized the value of ownership. It's meaningful to authors to be able to say, I own this and I can control it, right? I think then the question is, well, how much control do we think that authors should have, right? Maybe we want them to internalize the value of what it is that they produced. Do we want them to be able to stop people from using it in ways they disapprove? I think that's a harder question.
Right. Yeah. I feel like I'm not exaggerating. I want to study IP law now, but I'm too old to go to the university. I'm 46 next week, so I don't know. Maybe I'll just be an old lawyer.
Well, I mean, if you're interested in IP law, I actually have a whole series of videos on YouTube.
You do? Okay.
Where I basically teach an intellectual property class. So
what's the
if you go to my YouTube page is Brian L. Frye, just all one word. And there's a couple channels on there that are all about copyright and intellectual property law. So you can go ahead and check that out. And I have lots of papers if you really want to get in the weeds.
I may have you come back in. I really feel like we didn't even tap into too much of like
any time. Always happy to come on when you've got a copyright or other intellectual property related questions.
Yeah. Okay. Well,
awesome.
Yeah, and we do spaces and stuff. Maybe I'll hop in there and we'll have weird conversations. That's what we do.
Anytime. I'm always happy. Yep.
I think you got a brunch to get to, so go do your thing.
All right.
And, thank you so much for coming in.
My pleasure. Bye-bye.
Thank you. Take care.
Of meeting needs will be the day we enter correct Christianity. All this Christianity of gimme is actually paganism, modern day paganism. If all your Christianity is about God, give me car, give me wife, give me children, give me this, give me that, kill my enemy, kill my enemy, kill my enemy, give me, kill my enemy, give me. Anyone that doesn't want me to succeed, die by fire, die by fire, die by fire, die by fire, die by fire. Give me this, give me that. Kill my enemy. Give me this, give me die by fire, die by fire, die by fire, die by fire. If that is all your Christianity, you are a pagan rebranded as a Christian. You and the children of Baal are in the same WhatsApp group. I can give you a scripture. I don't talk carelessly, right? Give me